proceedings?
Well, it certainly seems like the end is in sight for the Oscar Pistorius murder trial, with the defense team today calling their final witness in this trial, of course, as you have already mentioned, being Professor Wayne Derman, who also came and really gave us, what he had interpreted during the consultations with the Paralympian. And we also saw two emails from other people with disabilities that the defense team tried to submit as evidence. Emails that seemed like these two people were sympathizing with the Paralympian, basically touching on the fact that Professor Derman told us in his testimony that people with disabilities have an increased fight and flight response, especially when faced with vulnerability. And of course, Judge Thokozile Masipa dismissed those emails, saying that they cannot be admissible and that they are irrelevant at this point in time. But let's speak more about today's proceedings, and I am joined by legal expert Dr. Llewellyn Kerr-Lewis. Now, of course, it seemed like victory for the state with those emails being dismissed.
Yeah, it's not a question of victory yet. At least one must remember it's but a small piece in a big puzzle. However, I do agree, I think the judge made the right decision. In terms of the South African law of evidence, those emails should have been excluded from evidence. It is inadmissible because purely it boils down to hearsay evidence, or at least opinion evidence of witnesses that won't be called by the defense to come and corroborate the contents of that email. So quite correctly by the court, I do concur that was the right decision.
Now, why would the defense pull such a move? Call witnesses that cannot come for cross-examination?
Well, remember, it's not a question that the defense called those witnesses. What happened here is those emails were introduced by a witness that was tendered by the defense when he compiled his report. So indirectly, they tried to introduce it in court. But obviously, Garinel and the court didn't fall for that trick. Remember, in terms of the Law of Evidence Amendment Act of 1984, 84 of 1988, it is admissible in certain instances, exceptional instances, where it's in the interest of justice. And I think Olwacher tried to persuade the court that this is one of those exceptions and should have been admitted under those circumstances. However, the court denied it, and that's where we are right now.
And of course, another interesting fact, the psychiatric report, the defense making their position known in court today. Advocate Barry Rue telling the court that they do accept the report, but not in its entirety, highlighting certain aspects. What do you make of that?
Well, that might be a problematic aspect later on as well. Once again, the evidence is already admitted, at least prima facie, which we call from a perspective of the law of evidence. However, the mere fact that you're not satisfied with the contents does not say take the matter any further. You must contradict it by calling evidence or cross-examining those experts in order to prove to the court that it should be inadmissible, or that the court should exclude certain of the evidence and the submissions that was made by these experts. So the mere fact that he testified from the bench and mentioned to the court that he's not accepting all the aspects is basically, from a law of evidence perspective, not taking the matter for the defense any further.
Now, of course, what are the benefits for the defense now that they have made known that they're not entirely happy with the conclusions in that report?
Well, once again, the mere fact that they've mentioned they're not happy is but a personal perspective of Barry Rue. He must convince the court that the court should exclude the conclusions of those reports, which hasn't happened up to yet. And unless he cross-examines or call witnesses to come and contradict it, it will stand. It was prima facie introduced, meaning ultimately it will become evidence in court, which the court must take cognizance of at the end of the day.
Now, of course, the report eliminates the possibility of the Paralympian having had maybe a mental defect at the time of the shooting. What can we read from that moving forward, perhaps in favor of the defense or maybe the state?
Well, it's not favoring the defense whatsoever. In actual fact, it corroborates the version of the state that he was of sound and sober mind, at least at the time of the incident, meaning that he did not have a mental defect or a mental sickness, which had an implication on his criminal responsibility. And to that effect, the only defense they can rely on, the defense now, is obviously the one they introduced from the outset, meaning that he acted in self-defense or at least to protect his interest and that of Riva Steenkamp on their version.
Okay, throughout this week, we saw a lot of testimonies that actually indirectly or directly deal with the athlete's state of mind. Now, what do you think is happening here?
Remember, ultimately the state must prove beyond reasonable doubt that he intentionally pulled the trigger in order to secure a conviction of murder. Otherwise, at best for them, they will only be successful on maybe a charge of culpable homicide. And intention has bearing on a person's mental capacity, a person's mental state of mind at that specific moment in time. And that's why the defense are so going for the mental issues as we are speaking here.
Okay. Now, with the last witness for the defense being called, could that signal the end tomorrow?
Well, obviously, until they have indicated that they closed their case, they can still call other witnesses. The mere fact that they indicated this probably is the last one is no guarantee. However, if we take them on their word for now, then tomorrow they should close their case, hopefully. And after that, we will wait for arguments. And after arguments, judgment will follow within a couple of weeks, I suppose.
All right. And that, of course, was Dr. Llewellyn Kerr-Lewis. He's a legal expert following the Oscar Pistorius murder trial with us here at the North Gauteng High Court in Pretoria. Now, as we have already told you, that the defense team called their last witness, meaning tomorrow it's cross-examinations of the testimony of Professor Wayne Derman, and that might mean that the defense might just rest its case by tomorrow.
Patricia Vasahi is at the North Gauteng High Court giving us an update of the Oscar Pistorius murder trial. We're going to take a very quick ad break, and after that, business news comes.